Great. Hello, everyone, and thank you so much for joining us for today's webinar on the National Interest Waiver. My name is Dustin Saldarriaga, and I'm a Senior Associate at Scott Legal PC. As I mentioned, today's webinar will be focused on a green card option that we've seen being used with increased frequency, which is the National Interest Waiver, the employment-based second preference category, EB2. National Interest Waiver. And one of the ways we've seen this used more and more often by our clients is to support entrepreneurs and those who own their own businesses. So today that will be the focus of our presentation, and we're fortunate to have my colleague Jiyae Hwang, who is also a senior associate at the firm. Jiyae has prepared a number of these applications and will bring her expertise to this presentation. Before we get started, there are a few things I wanted to note. The first is that our firm, while we do focus on business immigration, we handle the full spectrum of immigration cases, including family-based immigration and humanitarian immigration. So whatever questions you have or needs regarding U.S. immigration, we hope you will reach out to us. This webinar is being recorded, and after the presentation, we'll send you an email with a link where you can view the recording, as well as a guide, a comprehensive guide to the EB2 National Interest Waiver. We'll also send you a copy of the PowerPoint that you see on your screen, as well as a link where you can sign up for our future webinars. We do try to do at least 2 of these a month on a variety of topics. And finally, in that email, you'll find a link to our YouTube channel where we post a variety of videos, both short and long videos, including full-length webinars on a variety of immigration topics. So do check that out. Without further ado, I will go ahead and pass it off to Jiyae.
All right, thank you so much, Dustin, and thanks everybody for joining us today. So let's talk a little bit about first, what is the NIW and what does it entail? So the NIW is short for National Interest Waiver, and it is a subset of the EB2 employment-based immigrant petition. And immigrant petition means this is an application for a green card. So at the end of this process, you will get U.S. permanent resident status. Now, a green card, as you may know, gives someone the ability to permanently live in the United States and work for any employer or none at all. Having a green card also opens up the pathway to U.S. citizenship in the future if that is what you're interested in. And the NIW is really popular among individuals who wants to apply for a green card on their own. And this is called self-petitioning, right? You can apply as an individual, whereas in other categories, you normally need a U.S. employer, a company, to sponsor you for the green card if you're applying based on an employment-based sponsorship. Now, EB1A, the Extraordinary Ability Green Card, is another category that allows this self-petitioning by an individual who is the beneficiary, but typically the EB1A is really open to the individuals who have reached the very, very top of their professions and not as accessible or available to a wider variety of individuals as the NIW does. So in my experience, I have seen that the EB2 NIW is a more broadly applicable category for people, even in their relative beginning of their careers. Okay, so now let's go on and discuss what are the requirements, the eligibility criteria for an EB2 National Interest Waiver green card. So the first area to discuss is whether you meet the EB2 threshold to qualify under that category in the first place. So the EB2 threshold is really for advanced degree professionals, and you can meet this threshold criteria in 2 ways. So the first way is to meet it through showing that you have an advanced degree, which is defined as a master's degree or an above. Now, this includes a Master of Arts, Master of Science, but it also includes degrees like a Juris Doctor, JD, a Medical Doctor, MD, or an MBA, a business degree, because those degrees also require that you have completed a bachelor's degree to apply for these kinds of programs. Now, if you don't have a master's, if you don't have a PhD, JD, MD, or MBA, you can also meet the advanced degree criteria by showing that you have a bachelor's degree in your field, combined with over 5 years of progressive work experience in your field following your attainment of your bachelor's. And what does this mean? Let's break that down a little bit. So progressive work experience means work experience with increasingly senior duties and responsibilities. And frequently this means your title or salaries have changed in an upward fashion. Right. And the way to prove 5+ years of full-time work experience, and it needs to be full-time, you need to prove this by signed letters on company letterhead by previous employers or your current employer, if you have stayed with the same employer, stating the period of work that you completed, the terms and conditions of your work, and a detailed account of your duties and responsibilities that show how those duties and responsibilities have changed over time to include more senior and advanced duties. Now then, let's talk about exceptional ability for a little bit. So exceptional ability is another way, it's another channel you can use to meet the EB2 threshold. And this is available to individuals who even do not have a bachelor's, or even if you don't have a master's or PhD or JD or MD, you can, if you qualify under exceptional ability, you could also qualify under the EB2 threshold. So how do you prove exceptional ability, and what does this mean? So cumulatively, all of the evidence should show that you have a degree of expertise that is significantly above those ordinarily encountered in the sciences, arts, or business. That just means you need to show that you're not only providing good services to your employer, but you're doing so in a way that is exceptional in your field in terms, and that by that it means you're above the average in a significant way, and that is recognized by the evidence. So what does those evidences entail? So you do need to show you meet at least 3 out of the 7 criteria of evidences, and these evidences include, for example, 10 years of experience in your field, full-time experience, also proven through employer letters, as I mentioned above. You could also show that you have a related degree in your field. It doesn't need to be a bachelor's. It can be associates or other kinds of diploma that is relevant to your profession. You can also show that you have a related license that is required to practice in your profession. You can show that you have a membership in professional associations. And most importantly, you can show that you were recognized by others in your industry for significant contributions to your field that you have made. And this can be shown, for example, by awards won, by mentions in the media, publication of papers or patents or things like that that show an original contribution. So I would say that is really the core of your the evidence that you would collect for showing that you have exceptional ability, that you can show that you're operating at a level that is significantly above those similarly situated. Okay, so now let's move on now then to really the heart of an NIW petition, which is qualifying under the 3 matter of Danaher eligibility factors for an NIW. And let's break that down a little bit. So to clarify, just the fact that you qualify under the EB2 threshold by either an advanced degree or exceptional ability, that is not the end of the story. You do still need to show that your project, your qualifications, and the situation really merits a national interest waiver. So it is not sufficient to just qualify for the EB2 threshold. You do need to meet the national interest waiver criteria in order to qualify for that green card under this category. So let's break that down a little bit. So what are the 3 matter of Danaher criteria for meriting a national interest waiver? The first criteria is, does your proposed endeavor have substantial merit and national importance? And what does this mean? Substantial merit means a contribution, right, to your field, which can be in a range of different fields. It can be in the arts, it can be in the sciences, business, culture, but you do need to show that you are preparing a contribution to that field. National importance, what does that mean? It means that you are engaging in work that has broader implications than just, providing good services to your clients, providing good services to your employer. You can bring in something that is original or innovative that has national or global implications in a particular field, such as medical advances, for example, or improve manufacturing processes that can really change the way that things are done in your field more broadly. Now, the second criteria here is you are well positioned to advance the endeavor. And what does this mean? This means that your education, experience, and record of success in prior related endeavors give you the ability to really effectively advance the plans that you have proposed, which have substantial merit and national importance. And the third criteria here is that on balance, it will benefit the United States to waive the labor certification requirement for your particular case. And the way to show this is really to show that the benefits of your proposed work is broad enough to outweigh the ordinary benefits of the labor certification process, which is to protect one job spot for a US worker, right? So one thing to note here is that you must meet all three requirements to qualify for an NIW. And even if you meet prong 3, if you don't meet prong 1 and prong 2, it will not be a successful NIW case. So please do remember that you do need to meet all 3 prongs. All right, so let's move on to the next slide. How the National Interest Waiver can be used for entrepreneurs. So there are several ways that the new case law, which is matter of Danassar, and which is the governing case law for adjudicating NIW cases, changed how how NIW cases are evaluated to make it a little bit more friendlier for entrepreneurs to apply for an NIW. So let's break it down in a few ways. So for the previous case law, the focus was on, is the work being proposed national in scope, right? So there was quite a bit of large focus on the scope of your work, the geographic scope of your work. Is it going to be national as opposed to regional, being limited to one local area? However, matter of Danassar changed this. So after matter of Danassar, the relevant inquiry is not national in scope, but the inquiry is now national importance. And the case law clarified that even endeavors that focuses on one geographic area could have national importance. And let's consider an example, an entrepreneur, let's say, who set up a factory in Maryland, let's say, and locally producing and distributing an innovative architectural product that reduces waste and makes buildings more energy efficient. Let's consider that hypothetical. All of the hiring and the work being done is limited to one region, which is Maryland, right? But this endeavor could still have national importance under the matter of Danassar standards because it significantly advances governmental priorities, such as promoting energy sustainability in buildings, and does that in a large scale. So this really goes to show that because the focus is not on geographic scope of the endeavor anymore, a wider variety of entrepreneurial endeavors could potentially qualify for the for the National Interest Waiver green card. Now, another way you could show national importance is if you are an entrepreneur bringing in, let's say, a large-scale development project, significantly contributing to revitalizing one economically depressed area. So let's say there is a specific county in a state that is flagged as one with exceptionally high unemployment rates, depressed real estate prices, etc. And let's say an entrepreneur is coming in with a project to really revitalize this region and producing a high number of jobs compared to the total number of working population in that area. That could also be found as an endeavor that is having national importance, even though the benefits would be largely centered in that particular region. Now, another way that matter of Danassar made it more advantageous for entrepreneurs is that entrepreneurs enjoy an advantage in meeting the third prong of the matter of Danassar test, which is, on balance, does it benefit the United States to waive the labor certification requirement for a particular applicant? Now, entrepreneurs can have a leg up in this prong in 2 ways. The first way is by arguing that it is impossible or impracticable for an entrepreneur to obtain a green card through a conventional labor certification method because of their ownership interest in their company. That just rules out that that whole category for them to ever qualify for a green card, and the government will recognize that as a relevant factor. And the second way an entrepreneur could gain an advantage in meeting the third prong is by showing that the entrepreneur will create dozens of jobs through their business endeavor, right? And so we can argue that Congress's interest in making jobs available for U.S. workers is actually better served by letting the foreign entrepreneur come in and create jobs instead of protecting that spot and giving it to another U.S. individual. And a third way that matter of the NSR made it more accessible and more facilitated entrepreneurs to take advantage of the NIW is that an entrepreneur doesn't need to prove that the business will ultimately succeed, right? So matter of the NSR specifically recognizes that many entrepreneurial projects ultimately fail. And instead, the standard is whether the applicant presents a plausible plan with prospective impacts that rise to the level of national importance and showing that the applicant is well positioned to advance the endeavor. So it is a little different, right? You don't need to prove that your endeavor will ultimately succeed. You just need to prove that your endeavor will have national importance and it is a plausible plan and you are well positioned to advance the endeavor. All right, so let's move on to the next slide. Timing and other considerations when moving from a non-immigrant visa to an NIW, which is a green card. So let's first discuss the aspect of how do you apply for a green card and how does that really work? And I want to let people know that green card application actually has two steps, right? So the first step is the underlying petition, in this case, which is the I-140. That is the petition where you ask the government to find that you are eligible for a green card under that category. And the second step actually is to apply for a green card itself. So there are two steps, and applying for a green card can take two forms. Either you would apply for an immigrant visa through your home country consulate, or you would apply from within the United States, if you're already in the United States on a different non-immigrant status, to adjust status to a green card holder by filing an I-485. Now, let's talk about timing for the first part of this process, which is filing the I-140, the underlying petition for eligibility for a green card under the NIW category. Now, with premium processing, which is now available for EB-2 National Interest Waiver applicants, an action, which could be a decision, request for evidence, or a notice of intent to deny. So there are three possibilities of responses that the government can give you, will be rendered within 45 days of you filing the petition, right? And in practice, we have seen plenty of decisions which were approvals coming down actually a lot quicker than 45 days. So we have had a case that was approved as quickly as 7 days after we have filed the petition. So with premium processing, we can expect that you could receive an answer pretty quickly for the underlying portion, which is the I-140. Now, what if you do not what if you don't use premium processing? What about regular processing? How long does that take? So for the I-140 portion, usually regular processing can take up to a year to adjudicate just that part for the underlying eligibility for the green card. And let's say once you have the approval of the I-140, you can apply for a green card based on that approval. You can either do that through applying for an immigrant visa or applying for the I-485. And this process could take another year on top of that, right? And so right now, there is a retrogression in priority dates. And what that means is that there are a limited number of green cards available each year, but the number of applicants who are eligible and who want a green card is larger than the number of green cards available this year. So it creates a sort of a backlog, right? So you need to wait until your priority date becomes current before you can file for either an I-485 or start the process to apply for an immigrant visa through your home country consulate. And for many applicants who already have the approval for the NIW, their priority dates are not current yet because there is a backlog for I think it's many months backlog for the priority dates. And we don't know exactly when the priority dates are going to be current. So it is a situation worth monitoring. But this is just to say that the availability of green cards each year could create a further delay in applying for the green card for the second step of the process. So that's for timing. And now let's discuss a little bit about the issue of underlying visa status. So it is important to note that an NIW application is a green card application, and it is application for a green card. And if you are on a non-dual intent non-immigrant visa, such as a TN visa, for example, it could be very difficult to renew this once you file the I-140. Right. So the TN visa, for example, is one that is strictly assessed for immigrant intent. And so once you file the I-140, this is an expression that you are interested in immigrating to the United States. So the next time you come in at the border and try to renew your TN visa, you could be questioned about this. And the border officer may think that you have immigrant intent, which would not qualify you for the visa. And so the strategy for timing may be important here. So let's say you have an E2 visa, and let's say that your E2 visa is expiring this year, and you want to apply for an NIW. In this case, it could be a safer choice to first extend the E2 or first renew the E2 visa, right? And get a brand new E2 visa for 5 more years, and then apply for the NIW once you have that status. Because once you apply for the NIW, that is an expression of immigrant intent. And when you, for example, when you need to renew that visa at the consulate, it could be more difficult. All right. So let's talk a little bit more about the application process. I did mention this a little bit earlier. The first step is to apply for the I-140, the underlying petition. And with premium processing, you will get an answer within 45 days. If you get a request for evidence, an RFE, you would prepare the response for the RFE. And after you submit the response, the government will take another 45 days to respond to your RFE with a decision. And as I mentioned before, it takes approximately 1 year to get a result without premium processing. And if you get an RFE, you would submit the RFE, and the government typically takes a few months to respond to that RFE with a decision. The second step, right, is either applying for an I-485 or applying for an immigrant visa through consular processing. And if there is an immigrant visa available, and that means if your priority date is current, you may be able to concurrently file the I-485 petition. At this moment, as of the time of speaking, the priority dates are not current for EB2, the EB2 category, so you are not able to concurrently file the I-485 petition, but you can file the I-485 as soon as your priority date becomes current. Pros and cons of adjusting status in the United States versus consular processing. So adjusting status is very advantageous if an applicant's existing status is almost about to expire and they want to continue living in the United States in the interim while the I-485 is processing. And this is because just by filing the I-140, the first step of the process does not give you any status to continue extending your stay in the United States. Right. And it is worth noting that you can only file the I-485 if you're already in the United States on a different non-immigrant status, such as an H-1B or an E-2, and your priority date is current. So both elements need to be there. So once you have filed the I-485, the application for adjustment of status, you can continue staying in the United States until a decision is rendered in your application. However, it is worth noting, and this is a disadvantage of doing this, once you file the I-485, you cannot travel outside of the US without abandoning your application unless you apply for and receive an advance parole document, which is a travel authorization, right? So if you travel before you have the travel authorization, it'll be the same as abandoning your application. And travel authorization documents can get up to a year to be issued, and it could take a while. So you could be stuck in the US for that period where you have just filed your I-485 and you have not received your advance parole document yet. So that is certainly a consideration to take into account. Now, by contrast, if you choose consular processing and you apply for an immigrant visa through your home country consulate instead, this does allow you to continue to travel back and forth in and out of the US, and you can choose to maintain your underlying non-immigrant visa status. And this could really be advantageous if you need to preserve the ability to travel internationally frequently to your home country until your green card process is complete because of the considerations that I mentioned before. And one thing that I wanted to mention before we move on is that family members can definitely apply along with the main applicant. Your spouse and dependent children, unmarried and under 21 years, can also qualify for a green card as dependents alongside your application. All right, so now let's consider a little bit about the updated guidelines for STEM and entrepreneur applicants effective from 2022 January. Right. So in 2022, we saw a couple of guidelines be announced, which made it friendlier for science, technology, engineering, mathematics applicants and entrepreneurs in applying and qualifying for a green card under the NIW category. So one thing to note here for STEM is that the government published a list of critical and emerging technologies, which includes, and I will read off of my list here: advanced computing, engineering materials, advanced manufacturing, sensing technology, aero engine technology, agricultural technology, AI, autonomous systems, biotech, communications and networking, such as 5G networks, data science and data storage technologies, energy technologies, medical and public health technologies, quantum science, semiconductors, and space technologies. So if your proposed endeavor is within those areas, and if your proposed endeavor plans to introduce advances in those areas, then your application would be greatly favored in meeting the national importance requirement and the assuming that you meet the well-positioned requirement, you could have a leg up for qualifying for a green card. Now, if you have an advanced degree, which is defined as a master's or above in STEM, science, mathematics, engineering, technology, it is also favored for well-positioned. But one thing to note is that just having a degree is not the end-all be-all for meeting the well-positioned requirement. You do need to show a degree of related work, related experience, and a record of success in order to meet the well-positioned requirement. Now let's move on to discuss, can we go back? Yeah, I don't think I discussed the entrepreneur-specific guidelines. So after the new guidelines were announced, entrepreneurs may rely on several other non-traditional forms of evidence. And for example, ownership and critical role in a U.S. entity that they founded can be used to support that you're well-positioned to advance your business endeavor. For example, incubator and accelerator admission for a project can support national importance, or that the fact that you're well-positioned to advance your endeavor. Publication of intellectual property, not only if you author them, but if your company holds the intellectual property for patents, for example, that can be a positive factor for well-positioned and national importance as well. History of revenue growth can also help prove that you're well-positioned to advance your business endeavor. Letters from third-party reviewers, such as for example, if you receive venture capital funding from a reputable venture capital organization, if you could get a letter from that venture capital organization talking about why your business project has a transformative potential to the industry, that can help support national importance and well-positioned as well. All right, we can move on to the next slide then. So what is included in an NIW submission? So the first and important part of an NIW submission is collecting the proof that you meet the EB2 threshold requirement. And as I mentioned before, there are two ways to meet the EB2 threshold requirement. One is through showing that you have an advanced degree, or you have exceptional ability in your field of endeavor. Now, if you're meeting this through advanced degree, you will need to show a copy of your diploma or transcript showing that you have graduated successfully. And if it is a foreign degree, you would want to get a U.S. education equivalency report that confirms that the level of your education is the same as a U.S. institution at the same level. If you are meeting the advanced degree threshold through a bachelor's degree and 5 years of progressive work experience following your bachelor's, you would want to also submit letters from prior employers or current employers describing this progressive work experience on company letterhead. If you are meeting the threshold through exceptional ability, you would want to make sure you submit the evidences meeting at least 3 out of the 7 criteria for exceptional ability, and also the totality of the evidence should show that you are operating at a level that is significantly above those ordinarily encountered in your field. Now, the second part and the bulk of an NIW petition is to provide evidences that you meet all 3 criteria, which is national importance, well-positioned, and on balance, beneficial to the United States. So let's talk a little bit about national importance. Supporting documents for national importance typically include news articles, academic papers, market research, and government reports and press releases from government agencies that show why a certain area of science or your profession or your field is important for the national interest of the United States. For entrepreneurs, you would also prepare a comprehensive business plan that describes the offerings that you're developing for your business and what kind of impact this can have to the economy and to the field that you're operating in. And other objective evidence to show substantial merit and national importance. One very important aspect to consider is the prospective impact of your work, and this can be shown by significant interest from relevant industry actors and or government actors. Expert letters from relevant agencies can help. A record of the business plan receiving traction through receiving significant investment from third-party investors or being featured in media, for example, or industry publications, publication of intellectual property such as patents regarding the developments you have made through your business. All of these data can be relevant, and we would collect those data and submit it to the government to show that your plan has substantial merit and national importance. And to provide a little bit more detail on expert letters are a very important element of an NIW petition. Expert letters can support both that your work has substantial merit and national importance. It can also support that you yourself are well positioned to advance this endeavor by really showcasing examples from your past projects and discussing how these past projects impacted the field in a broader way, to use those case studies to demonstrate that you will also experience that level of success in your present proposed endeavor in the United States. With regards to well-positioned, I encourage clients to collect all relevant evidence of their past achievements in their field that could support the fact that you have the ability and skills to see this project to success. For example, academic papers, if you've authored any papers, and if you already have a business that you have run before, or if you have a business that you're currently running, you could submit revenue and hiring statistics through tax returns and other objective evidence to show that you have already seen significant growth and progress in your business, which can support future projections of future growth. So that can also be very helpful. If you're an entrepreneur, as I mentioned before, pursuant to the 2022 updated guidelines, if you can show proof of ownership of your US-based entity, that can also support that you are well positioned to support your endeavor. And as I also mentioned before, proof of securing investment from venture capitals, proof of admission to prestigious incubators, accelerators, that can also come in to support the well-positioned prong as well. Finally, proof of interest in your projects by leading government and industry actors can always be a plus to an NIW petition, because it shows that you're offering something original to the field that is bolstered by that has generated significant interest among the public. So this can include proof of contracts, letters of intent, and as I mentioned before, startup capital, proof of investment that can show that you're ready to see this project to success. Okay, so now then, let's discuss a case study of a successful case where an entrepreneur qualified for an NIW. And let's discuss the 3 prongs and how the applicant met them. So substantial merit and national importance. So what did this applicant propose to do? Now, this particular applicant was an entrepreneur, and the applicant proposed to set up a small consulting firm focused on doing projects with relevant organizations in U.S. veteran space for the purpose of improving veteran services and increasing accessibility of productive job opportunities for wounded warriors in particular. So he submitted a business plan, and in that business plan, he explained that he would coordinate specific organizations and projects to facilitate the reintegration of these wounded warriors. And he also included letters from prospective clients and prospective partners to describe how his projects will improve existing program offerings. So that was key. So what he did was he identified a gap in the industry where in philanthropy, where there was a limitation of the programs available for wounded veterans that really effectively assisted this transition. And he explained why his program was different and would fill this gap essentially, right? And the partners that he discussed in the business plan, and also the partners who provided those letters of support, included leading philanthropic organizations, government entities, and businesses in the United States. So that was a significant help to his petition. In addition to this, the petitioner submitted government reports, news articles, and letters from senior officers in government and philanthropic organizations that really explained this gap in veterans care and this lack of effective services, and how this person's specific project will help fill these gaps. Now let's move on to talk about how this applicant was able to show he was well positioned to advance the proposed endeavor. So the applicant had a very remarkable success record in past endeavors in the UK, where he was from, and he was able to obtain letters from senior officials from government who had previously worked with him and provided testimonials to his achievements. So, for example, he had previously played a leading role in developing and implementing initiatives to connect public and nonprofit organizations in the UK to benefit wounded warrior and veterans priorities. And one of the letters had this testimonial: without him and the significant impact that he had, we would not have realized the considerable success that we had seen in the areas of veteran job placement, reintegration into civilian lives, and expansion of critical services to this population. And another aspect that really helped him was that he had a very high level of understanding and network connections in the United States and UK charitable sectors that no other person could bring. And this was proven through expert letter testimonials as well. And the scale of this impact was really large. And one of the expert letters testified that tangibly his work has enabled millions of dollars in charitable efforts to be productively connected with service organizations in the US and the UK, and change many veterans' lives through this process, which really supported the fact that he was indeed well positioned to continue this work in the United States. So in sum, he had a detailed business plan with details about the types of services he would offer. He identified specific names of clients. His business plan was credible. It was supported by evidence of multiple letters of support and correspondence from potential clients and collaborators. And also he had submitted business financial statements showing that he has sufficient startup capital to really make this plan a reality. All of these facts supported that he was well positioned to advance his endeavor. Now then, let's talk about the last prong, the third prong. On balance, how did he show that his work would be beneficial to the United States, such that it would be on balance beneficial to waive the labor certification requirement for this particular person. Now, as I mentioned before, it is required to also meet prong 1 and prong 2 in order to get to prong 3. In this case, he had an easy time meeting prong 3 because being an entrepreneur, he was self-employed, and it would be impractical to obtain a labor certification for this person in particular. And the government recognized the immense value in improving programs and assisting organizations that support the welfare of U.S. veterans and wounded warriors. Finally, the fact that he had a past record of success, and there was evidence of demand of his services by letters from potential clients, high-profile clients in the United States, such that the government was able to conclude that the U.S. would indeed benefit from these contributions, even if other qualified U.S. workers were available to perform these functions. He would be able to do this in a much better way to benefit the U.S. In a much greater degree than would another worker with minimum qualifications.
Perfect, Jiyae. Well, thank you so much. I will just quickly say to the audience, if you do have questions, feel free to send those in. Otherwise, we will go ahead and wrap this up. Jiyae, thank you for taking the time to share your expertise. For those of you in the audience, do keep an eye out for our future webinars. And we will follow up with an email that gives you a link to sign up for those. So thank you again, Jiyae. Look forward to seeing you all soon.